Hello and welcome to Brethertons, and today we're looking at the issue of personal injury, and with me are Richard Pell and John Rees. Richard, you've been, I understand, in personal injury law for quite a number of years. How serious does an injury have to be before a claim can proceed?
Well, we deal with injuries which are very serious and very minor injuries. People can have a minor injury for a slip or a trip, but they could have a catastrophic injury, for instance a spinal or a brain injury.
And presumably you've seen all those sorts of cases?
I've seen all those things and all those cases during my time, yes.
Are people paying for you as soon as they've walked in the Brethertons office door then?
No, they don't. They don't have to pay. We provide an initial free interview, which is at no cost at all to the client, when we will assess and evaluate their claim. If we consider that they have got a good claim, we can then continue to advise them on what's called a no-win, no-fee basis.
Right. But you'll be realistic with a client, will you, if you don't feel it's one that's worth pursuing?
Oh, well, if they haven't got a claim, we will tell the client straight away.
And I think that's become more and more the case, has it, with the television adverts?
Well, I think people come in having had something happen to them, and they think because something's happened to them, somebody's always to blame, and therefore they can make a claim. I mean, there's a TV advert to that effect, isn't there? But that's not always the case. Okay.
Well, if it does lead to compensation, what kind of levels might be involved?
Well, for the very, very serious cases, it can be millions of pounds. For a minor slip, trip or whiplash, it could be £1,500. There's a huge difference between the two.
And you have to be, make sure people are realistic about what kind of money they can expect.
But we have to manage their expectations when they come in, of course.
Yeah. John, what is that process then to getting to compensation?
Well, I think it begins by remembering that you have a choice as to which solicitor you instruct. Often these days, clients, I think, find themselves being channeled towards a particular solicitor they may never have heard of, but they do have a choice. You can pick up the phone, you can log on onto our website. We're quite approachable, us solicitors, and we'd be very happy to try and help you.
So don't always think about the adverts and ringing their numbers?
Well, no, not necessarily. I mean, your claim might end up being posted to some panel firm that you've not heard of at that point, and money's probably changing hands for it. If that's what you want, then fine, but it is your choice as to where your claim is dealt with in the end. And
we often think that legal claims equals ending up in court. Is that always the case?
Statistically, you're unlikely to end up in court. Most cases are resolved before it gets to a trial. It's something that we deal with at the very outset in pursuing the case. We find that clients have four main questions at the very outset. It's: have I got a case? How much is it going to attract in terms of compensation? How long will it take? And what's it going to cost me? All of these things depend, as Richard was saying, on the kind of case it is. But most cases don't end up in court at a trial, and most cases don't involve us sending out huge bills to clients.
I know Richard mentioned no win, no fee.
That's right. Most cases in the country, a personal injury claim these days is likely to be conducted on a no-win, no-fee basis. And what that means is that if you win the case, then the opponents will be paying your legal fees. If you lose the case, then those fees are effectively written off.
Gentlemen, thank you very much. And don't forget, if you'd like a free consultation without any obligation, just contact your nearest Brethertons office.